Meeting to order. My name is James Miller. I'm the chairman of the board. Meeting is called to order. First order of business is roll call.
For the members of the planning board, we announced Andy Bacon, absent Olin Gambrell,
Here.
Eric Curtin,
Here.
Tom Silveria,
Here.
James Miller,
Here.
Chris Souza,
Here.
David Hontoon,
Here.
Thomas Heaney, here.
All right, I've lost, I don't, give me
Hey.
one.
Sally, my name's Chris Souza. I'm on the Zoom call like you are.
All right, well, what's happening now is I'm getting cut off every time someone speaks. So let me try to get you back on the screen. Hold on, please. I'm sorry. Are you able to see me?
No, we are not.
Hold on. Okay, I have everyone. Just be sure to state your names, if you will, please, when you speak.
Jim Miller. I'm going to call Marissa Desautel to open our proceeding tonight by instructing us.
Good evening, Marissa Desautel. I am conflict solicitor for the town of Middletown Zoning Board of Review, sitting as the Board of Appeals tonight. You all should have a memo that I circulated by email to the town on October 28th, which outlines the overview of your role tonight as the Board of Appeals, as well as the standard of review, which is outlined in state law, the procedure that I suggest we follow tonight, and hopefully you've had a chance to review that memo. If not, that's fine. I can go over it quickly now if you'd like, or not. Why don't you let me know how you'd like to proceed?
Marissa, I think everyone's had plenty of time to review the memo. I'd ask them to ask any questions if they have them before we go forward. And my only question to you is, in tonight's meeting, since we're sitting as the Planning Board of Appeals, I'm not sure there's a place for public input unless it has to do with the planning board's procedures per your memo. Am I off on that, or?
No, you're exactly right. I would advise that you will only want to consider evidence and testimony that is part of the official record of the proceedings below. Accepting new public comment at this point would not be appropriate. And you're correct that it is a public meeting tonight, but it is not a typical public meeting where you allow for the public to come in and provide testimony that you would then consider in rendering your decision. You are confined to the record.
Okay, I just wanted to make sure that I had read that correctly. Does anyone on the board have any questions for Attorney Desautel? Seeing none, I guess Marissa, then we should allow the attorney for the petitioner to go first.
That is correct.
Okay, Mr. Martland, are you on the line?
Yes, Mr. Chairman, David Martland, it's Martland. I represent Eugene Goldstein, who is the owner, the applicant, and in this context, the appellant. I'm not sure if Celeste got an email I had sent earlier, wondering if I could have share screen access for I've got two accounts here, one under David M., the other David Martland. So if the David M. Could have a share screen access, I'd appreciate that.
Sorry, I left the building at 4 o'clock today. We don't have that availability right now, Mr. Martland. It would take a few minutes for us to get the TVs on and get connected.
Oh, I thought we had utilized that in prior zoning hearings. I thought,
Yeah, we do need advance notice, and unfortunately, I did not get your email. I left the building at 4 o'clock. I was on a Zoom meeting myself at 3 today. So I did not receive your email, Mr. Martland. I'm sorry.
How long would that take?
Is there any way Dave could blast it out to the zoning board members real quick and we could look at it on our cell phone or our laptop or something?
Just go ahead and set it. Put it on. We'll just wait for 10 minutes.
David, can you start your points and then we can get everything up and running?
sure, I can do that.
So we're in the process of getting the televisions turned on.
Okay. I apologize for the late notice on that. I didn't realize that you'd have to go through that process for that. So the matter this evening, obviously, the board is aware, is an appeal from a decision of the planning board. My client, Gene Goldstein, is the owner of property located on Prospect Ave. It's roughly 9.19 acres of land. It's presently a vacant parcel of land. And we had filed an application for subdivision for an 8-lot conservation style subdivision back at some point in 2016. The conservation style subdivision is required for all subdivisions that are over 5 lots. Anything that qualifies as a major subdivision at the time was required to go under conservation style subdivision. So that's what we did. And that matter came on to be heard February of 2017 by the planning board. And the planning board granted a unanimous approval of the master plan for the 8-lot major subdivision. And along with that, granted certain waivers.
Mr. Martland,
Yes.
we've got the televisions up and running. You should be able to share your screen at this time.
I don't see that I have share screen access.
All panelists can share, it states. Should be able to.
And I have 2 accounts that are logged in. I was looking for the one with David M. Oops. Okay, I see a share screen now.
There it is.
Great. So this is, as I was stating, we had received a master plan approval in February of 2017 for this project for the proposed 8-lot subdivision, subject to certain conditions and waivers that were set forth. And one of those conditions here that the board made the following positive findings. One, that the proposed development was consistent with the comprehensive community plan and had satisfactorily addressed all the issues where there might be inconsistencies. Two, the development was in compliance with the standards and provisions of the town zoning ordinance. Three, that there were no significant negative environmental impacts from the proposed development. Now, this was only at the master plan stage with respect to that finding. Four, that the subdivision will not create lots where physical constraints would make building on the lots impractical. And finally, five, they found that all lots would have adequate and permanent physical access to a public street. Now, the plan that was before the board at that point was, essentially the same plan that went to the board for the preliminary plan approval. Now, following this initial approval of the master plan in 2017, of which it was known that the applicant was going to rely on private wells. And if I would just show you here from the minutes of that meeting. I'm just showing you the minutes from February 8, 2017 from the planning board. Highlighted here that it was the request for the master plan approval. And highlighted in this section that there were concerns raised regarding the 8 wells by Barbara Arietta, Brian Skelly, and a discussion about these issues. And in here, we had indicated at that time that we had looked at the cost of bringing in public water, and that water to the site, bringing that would make the project infeasible. So we had that discussion at the master plan stage. Also, Mr. Croce in this section asked how the concern about the impacts on the wells could be addressed. Can an analysis be performed? Mr. Martland noted that as lots are developed, the adequacy of the individual wells must be confirmed before the building permit will be issued. And Mr. Regan stated that the board should be careful about requesting analysis that is not typically required in similar cases. The applicant will provide more detailed information at the preliminary plan stage of review. So it was clear at the master plan stage that the applicant would be utilizing wells and would not be relying on public water for this subdivision. The board went forward and approved that. And Mr. Goldstein then began the process of having the engineer do, the full engineering, going to DEM, and ultimately, after getting those DEM permits, we filed an application for preliminary and final approval in September of 2017. We then spent, essentially the next 2 years having the project reviewed extensively by the town's technical review committee and by Crossman Engineering, whom the town hired as the consulting engineer. Through that process, we were required to make changes to the plans to satisfy concerns raised by either the town or Crossman Engineering, required revisions and resubmittal to DEM. And then finally, we were able to get back before the planning board on October 9 of 2019. Following that very extensive review. As the board is aware, we had that hearing that night, and I'll go into a bit more detail later, but ultimately we were denied on a 3-3 vote for preliminary plan approval. And that's what has been appealed to the board this evening. This is the notice of the planning board decision. It was part of the record and submitted in connection with the brief that was submitted. And it states in this, the reasons given by those voting in the negative included the following concern: based on the evidence presented during the meeting and statements in the September 5, 2019 review memo by the town's consultant, Crossman Engineering, the application as presented would not allow the board to make the required finding that there will be no significant negative environmental impacts from the proposed development as shown on the final plan with all required conditions for approval. So we're here this evening appealing this decision, and it's the board's function to, it's unusual, typically the board hears testimony, but you're not going to be hearing any testimony. It's your function to review the record and to hear argument of counsel and make a decision based on that. And I believe that Ms. Desitel laid out the standard necessary, and it's set forth in Rhode Island General Laws 452370, standard of review, that the board shall not reverse a decision of the planning board except on a finding of prejudicial, procedural error, clear error, or lack of support of the weight of the evidence in the record. The Superior Court has had occasion to look at this particular issue in the matter, the case of Polly's versus Ferrazzano, which is cited by Mr. Jackson in his memo. And this is a case in which the planning board denied a subdivision based largely on environmental concerns regarding wells and septic systems. And in that situation, the zoning board overturned the decision of the planning board. And that was appealed to the Superior Court, and the presiding justice, Justice Gibney, rendered this decision. And in it, she expressed what's required of a zoning board in reviewing the when they're sitting as a board of appeal. And the reason why I raised this is there was contention in, I believe it was Mr. Jackson's memo, where Mr. Jackson indicated that it's the function of the board only to determine if there was more than a scintilla but less than a preponderance of evidence. And in this case, and the court rejects that notion and says that the plaintiffs misconstrue that statutory standard, and that the Board of Review is allowed to weigh the evidence. And they states it's clearly necessary that the Board of Review participate to some extent in weighing the evidence if it is to determine whether the planning board's decision is against the weight of the evidence, although the Board of Review does not utilize the de novo standard. So I believe this evening, it is part of your purview to review all of the evidence that was presented during the course of the hearing and to actually weigh that evidence and determine where does the weight of the evidence lie? Was there more evidence presented to support our contention that there would be no negative environmental impacts? Or was there more evidence on the side to indicate that there would be a negative environmental impact? That, I believe, is the function of the board with respect to looking at the weight of the evidence. Now, for those members that aren't familiar with the actual proposed plan, I imagine everyone is, or anyone looking, any members of the public, this was the plan that was before the planning board on the evening of October 18, or actually earlier. The decision was October 18. This is the matter that was before the planning board. It's an 8-lot subdivision. There was a proposed right-of-way that accessed Prospect Avenue. Basically, the 8 lots are located along the westerly side of the road, with one to be located at the southerly portion. There is the neighborhood to the west, where Tony Lynn Terrace is, where there are a number of the objectors that is noted in the testimony from Crossman Engineering and cited by Mr. Regan, that neighborhood is serviced by public water. There's water in Tony Lynn Terrace. So this is the fairly straightforward subdivision. The lot, the open space lot, is located on the westerly side, which is essentially kind of the downhill side, and the detention basins are located in the area against where the trailer park is. So that what was the plan set that was before the board. He's just this shows bioretention areas that would be located and potential location for wells for each of the lots. Now, during the course of that hearing, we presented the testimony of Dr. Aldinger, and we presented a report and which is part of the record and was submitted to this board. The report was extensively reviewed by Crossman Engineering. And I think when you review the record, essentially, Dr. Aldinger and Crossman through Steve Cabral essentially agree on all conclusions drawn in that report, with the exception of one, and that dealt with the amount of recharge of rainwater in this location. So what we presented was that the report determined there's on average 46 inches of rain that falls in Middletown on a given year. And of that 46 inches of rain, 10 inches would recharge into this site. So without looking at recharge volumes from any off-site situation. Cabral from Crossman Engineering thought that this was too high a number, although our expert adamantly believes and testified that he thought that was reasonable and certainly in keeping with all scientific standards, and he came to that conclusion based on a reasonable degree of scientific certainty. Cabral believed that the amount of recharge would be should be lower, and thought it should be 5 inches. So out of the 46 inches of rain, only 5 inches would get back into the recharge in a given year. But when you look at that, that creates a balanced system. There would be no negative impact. Both Crossman Engineering and Cabral agreed there would be no negative impact associated with that based on their years of experience, their knowledge, and the conclusions that they've drawn based on that. The site itself was estimated to contain a significant amount of water. Anywhere in the bedrock of 600,000 gallons to 7.5 million gallons of water, plus the amount that would be held in the till, which could be up to 3 million gallons of water as it presently sits.
Dave, did you say that the water is anywhere from 600,000 to 7.5 million gallons?
Yeah, yes.
Very wide.
Within the bedrock. So up to 3 million gallons in the till, and depending on the certain factors, anywhere from 600,000 to 7.5 million gallons. That was the total storage within the bedrock. So in his testimony, Aldinger said that so based on a reasonable degree of scientific certainty, we conclude that developing the 8 bedrock wells is not likely to cause any negative impacts on the nearby wells because the demand is really low. Roughly, this is an error in the stenographic record. It's roughly 2.4 million gallons per minute. It should be, the demand is roughly 2.4 gallons per minute. Groundwater recharge of 2.3 million gallons per year. He says ignores the groundwater recharge from the stormwater system, which is about 1 million gallons. And the new wells on the west side of the site are 145 feet away from the nearest well and 380 feet away from the trailer park. So it's highly unlikely that the majority of the water from these wells, or that these wells will draw, will be coming from on-site recharge. From our analysis, we've concluded to a reasonable degree of scientific certainty the following: drill wells have been developed in the site vicinity and reported yields of 4 to 28 gallons per minute. We're looking at less than 1. We conclude that the additional wells can be developed with adequate yield in the bedrock. There's adequate groundwater recharge to provide the required water supply, and there's also adequate storage in the bedrock aquifer. The estimated demand for 8 residents is only 1.3 million gallons per year with a groundwater recharge of 2.3. So there's an excess. There are private and public wells in the site vicinity. However, we don't believe it's likely that these wells will be adversely impacted because of the water demand for these new wells is a relatively small amount. They're a substantial distance from the existing wells, and the recharge from these wells is likely to stay within the site boundary. That was the essence of the report, is that there would be no negative environmental impacts, that there is sufficient water for these 8 wells, and Cabral concurred with this. And in Cabral's testimony, he says, now, as in recognition of the concern we had, Paul do a scenario where instead of having 10 inches per year recharge into bedrock, he did look at what would happen if we only infiltrated 5 inches, which is in line with we feel is a reasonably conservative value. And when Paul made this analysis, and Paul is Paul Aldinger, made this analysis over, I believe it was a 1-year term, and he used the average daily flows for the 8 homes, and he assumed only 5 inches per year. There was a balance. So once I saw Paul's revised analysis in response to our concerns, then I was confident that what Paul was saying is true. There is adequate recharge on the site, assuming our conservative values of only 5 inches per year, that the site could support itself. That's from the town's engineer. Now, I know that one of the issues that I believe that Mr. Regan raised in his memo dealt with the use of the word gamble by Mr. Cabral. So I think it's probably important to look at this portion of the transcript. Because it seemed as though that what the intent was in the memo was to seem that it's a gamble to use wells because they could impact the environment negatively. But if we pick up here on line 2 at page 82, but as I've always said in past meetings and this meeting is that there's a bit of a gamble, but it's a historically reasonable gamble that the well depends on how the fissures are interconnected. And that goes back to the experiences that I have overseeing municipal water company, is that in the section of town where we have bedrock wells, it was very common that in time the homeowners would periodically have to dig a deeper well. And it may have been that when the wells were first installed in bedrock, they may have only been 100 or 200 feet. And that's why we're recommending that they go in initially at 500 feet. So this notion of a gamble was whether or not the well itself would be drawing sufficient water to support the house. And what Crossman Engineering, Steve Cabral recommended was that the wells be dug to a depth of 500 feet, which would gain additional storage space for water. And it would be a few days of supply that could be stored in each one of those wells. So this is a question that was posed by Mr. Nash to Mr. Cabral. I don't see it getting to a level impacting environmental concerns. But if you want to just maybe touch on that, Mr. Cabral, yes, that is true, especially after Paul, we ran his numbers. And like I said, he assumed only 5 inches per year over a 1-year demand using the average daily flow of 8 homes. The numbers were essentially a balance. So that alleviated my concerns. Further on, Mr. Nash, but it doesn't rise to a level that makes you concerned. That is, that there's, Mr. Cabral, no. Mr. Nash, going to be additional, any adverse effects from this? Mr. Cabral, no. And there's Mr. Nash again, and there's inconsistencies. You're going to have ups and downs, good years and bad years, but nothing to the level of Mr. Cabral. The answer is true. My largest concern, as I've mentioned in the memos, was the impact to the adjacent public wells. And the public wells that Mr. Cabral was referring to are the public wells that are located on the property and the mobile home park. And as I explained to the board, the planning board that evening, my client actually acquired the mobile home park and had no concern relative to the impact on those wells. And so that's just to give you a little backdrop before Mr. Cabral goes on and says, in knowing that this land actually does recharge the aquifer that they draw water, but it was good to hear today that this applicant actually owns those wells. So then in essence, if there is an impact, it's the applicant impacting himself. And this is also from Mr. Cabral on page 85 at 18. So personally, I believe that there will be adequate water for the 8 homes. The true impact to the existing public wells is unknown, because I believe these wells are at a depth of only 136 feet. So if there is an impact, it would be on these wells. But like I said, it sounds as though the applicant would have to deal with those. So Mr. Chumo, on page 89, again, in questioning the town's expert, states, Steve, I want to read this last part of your analysis, and I want you to put my fears at rest. The analysis indicates that demand versus recharge deficits can be expected. And if adjacent wells rely on the same recharge area, the deficits will increase. A deficit indicates the demand will need to be satisfied by diminishing groundwater storage. That you feel comfortable that there's not going to be a situation. It seems like you now feel comfortable about the whole situation. Mr. Cabral, yeah. See, Mr. Chumo, an adequate supply? Yeah. In right above that statement, I addressed the different scenario. I was trying to summarize the different scenarios that Paul analyzed. Further on, Mr. Chumo at page 90, line 17. All right. And after Paul's presentation, do you feel satisfied that there's going to be adequate water for the new wells, Mr. Cabral? Well, actually, Mr. Chumo, the existing wells, Mr. Cabral. And actually, my comfort with 5 years per year and the average demand was based on the analysis that he provided, say, a few weeks ago. So I was not swayed by anything Paul said today, meaning Paul didn't give any new information that altered my conclusions. My conclusion is based upon the most recent scenarios Paul provided maybe a week or two ago. Now, I spent time to go through that just to really, hammer home the point that the applicant in good faith worked with the town, worked with the town's consulting engineer, the town's technical review committee over a period of 2 years to address any potential concerns, and didn't present this petition to the planning board until we worked through all of those issues. So you've got testimony, competent testimony from 2 experts on these issues that was delivered to the planning board. Yet, the planning board denied this application. It's our contention that the only competent evidence in the record is from these two experts. The appellants have tried to raise, or the appellees, the abutters, and Mr. Regan for the board, they have tried to raise the issue that there was lay testimony presented that was competent and could overrule the testimony of the experts. However, our contention is the only competent testimony on the issue of the potential impact a development could have from an environmental standpoint and from a well standpoint has to be delivered by an expert. The lay testimony is not competent on that point. And to that, I would refer back to that case, Polly's versus Verrazano, in which the Superior Court did look at that particular issue and the potential impacts on the proposed development. And in that case, as we did, the developer presented testimony of experts. The objectors did not have expert testimony. They provided testimony, lay testimony. Ultimately, the planning board sided with the abutters and turned down and denied the subdivision. That went on an appeal to the zoning board. And the zoning board reviewed that. They overturned the planning board's decision. And one of the contentions that the abutters raised at the Superior Court level was that, and they cite the case of Smith v. Zoning Board, that they argued the planning board could use conflicting lay testimony and their own expertise to deny the preliminary plan application. Superior Court says the reliance on Smith's misplaced. And Smith, although the Rhode Island Supreme Court held the zoning board might rely on its knowledge in considering whether to grant a special use permit, it also held that lay testimony relating to issues properly within the province of expert witnesses carried no probative force. Furthermore, while a planning board may be presumed to have special knowledge of matters that are particularly related to the administration of a zoning ordinance and local conditions as they are affected by the provisions of the zoning ordinance, board members are not presumed to be qualified as experts in any trade, occupation, or profession, even though these may relate to the use of land. Thus, the planning board's own analysis of the data presented by the applicant, by which it arrived at different conclusions from all the qualified experts, is not probative evidence. Also, the court noted here, finally, in arguing for the reversal of the Board of Review's decision, the plaintiffs argue that it was logically flawed because the Board of Review relied on supposition to refute direct observation. The plaintiffs cite Restivo v. Lynch for the proposition that testimony is competent when it regards observed effects and physical facts, and claim that the objector's lay testimony consisted of observed facts. Now, this is important because both Mr. Regan and Mr. Jackson do cite Restivo v. Lynch for this proposition. The court held here that this argument is without merit. The testimony cited by the plaintiffs did not relate to facts, but instead to the unsubstantiated concerns of the plaintiffs. In contrast, the lay testimony in Restivo consisted of objective statements that they had observed the property to be developed and that did not drain well. It is quite clear that the objectors have not directly observed the effects of this yet to be built subdivision. It is equally clear that the planning board erroneously relied on lay opinions on matters properly addressed by experts. Accordingly, the Board of Review's conclusion that the planning board's findings were contrary to the overwhelming weight of the evidence in the record, and they essentially ignore the evidence in favor of lay conjecture and speculation is not clearly erroneous. Now, there was testimony, lay testimony that some folks on Prospect Avenue may have had problems with their wells, but that has zero relevance as to what the potential impact of a development could be on an aquifer. So the only credible testimony associated with these impacts was that of the experts that we presented, and reliance on the lay testimony. Well, I assume reliance on the lay testimony was inappropriate. And I say presume because, quite frankly, when you look at the transcript, when the board took their vote, the folks who voted against this, I mean, this was denied. There is really nothing expressed as to the basis for the denial. Now, the planning board's brief tries to indicate that they try to poke a couple of holes into the report submitted by that we submitted, the Aldinger report, but none of those were raised during the course of the hearing. Not one board member raised any of those issues or said the report wasn't credible. So we might be having a different discussion had any of the, an issue had been raised, and we would have discussed it. But none of these issues were raised. Mr. Cabral, on behalf of Crossman, didn't raise those issues. And, I just, a little shocked that, we find ourselves, looking at those. And some of those issues that were raised is the reliance on surveys conducted in past years regarding, the type of geology that we have here on Aquidneck Island. When I took a geology class, I learned that geology was measured in, eons, not years. So those particular issues weren't raised by any of the board members. There was also an issue, both Mr. Regan and Mr. Jackson put forward an argument that we failed to provide evidence why public water could not be brought to the site. At the outset, if public water was readily available, I would think any developer would bring it there. However, that is not a requirement of an applicant to provide any such evidence in the context of the planning board hearing. We are not legally required to provide evidence regarding why we can't hook up to the public water. That also was not raised during the planning board hearing. I would note our plans were certified complete. And so we had a fully complete and certified application. Now, Mr. Regan and Mr. Russell refer to a general law. And it was 452341, which indicates in a preliminary plan phase that in addition to providing the site plans, an applicant's also required to provide all permits required by state and federal agencies prior to the commencement of construction, including permits related to freshwater wetlands, coastal zone, floodplains, preliminary suitability for individual septic systems, public water systems, and connections to state roads. Well, we weren't hooking into a public water system. We were providing, my client's providing wells. So there is no permit that's required. Just like we weren't required to provide a permit related to the coastal zone. This is beyond the jurisdiction of CRMC. So some permits are required to be submitted, others are not. And when you're not hooking into a public water supply system, there is no permit that is required. Now, also to suggest that the issue of the use of wells as opposed to the use of public water was not addressed is false, because it was addressed, as I indicated earlier, at the master plan stage. And the plan was approved by the board with express knowledge that we were using private wells. There was no requirement or condition placed on the applicant to further investigate the use of the public water system. That just is sort of a red herring. And there's no requirement to prove this. So, I think there was one other issue where both Mr. Regan and Mr. Jackson have tried to attack the testimony and reports submitted by Mr. Dr. Aldinger, arguing that he used the word likely. It would not likely create a negative impact. And I just want to say, that's a term of art for experts. It is used by experts in the context of these matters and in civil matters, because you're required to prove certain elements by a preponderance of the evidence. And whether or not you say preponderance of the evidence or it's more likely than not, that means the same thing. It is greater than 51%, which is what is required of an expert. So that is simply the type of language that's used when doing expert reports. And so Mr. Aldinger clearly said that he conducted it, the analysis, and that he's concluded to a reasonable degree of scientific certainty that we do not believe it likely that the nearby wells will be adversely affected since the water demand for these residents is relatively small. The wells are planned to be a substantial distance from existing wells, and the recharge area for these new wells will likely stay within the site boundary. And Mr. Cabral concurred with this. So I think when you review the whole record, the weight of the evidence is clearly on the side of the applicant, Mr. Goldstein, that the board committed error by relying on lay testimony or speculative testimony that was not supported by expert testimony, and that this should be overturned. The board decision, the planning board decision should be overturned, and then the matter remanded for final approval. Thank you.
Thank you, Mr. Martland. Before we continue on, I'm going to take a short recess of 5 minutes to give the board here a break, and then we'll resume at 7:10.
Thank you.
Hey, Jim. Jim.
Chris, you're not muted.
Oh, thanks, Peter. Hey, Peter. Peter?
Yes.
I was going to ask Jim a question. I can just ask you. Are we going to get to question the attorneys, or do we just listen? Is David done?
I assume so, but
If we want him to clarify something, do we ask him to clarify it?
I would leave that to Jim and Marissa.
Okay.
Since she's advising you tonight.
All right.
Yeah. Hopefully we can move this along.
Mr. Martland? Mr. Martland?
Yep. I'm just unmuting
Hi.
myself.
Could you unshare here for us so we can take this off the screen? Thanks. There you go.
Sorry about that.
Thank you.
Okay.
Appreciate it.
Okay.
Marissa, would it be appropriate now for Mr. Reagan to go forward, or should we have Mr. Jackson?
No, I'd recommend that Attorney Regan start now.
I was actually going to defer to Mr. Jackson, who represents the abutters, if, unless the board has an objection to that.
I
I
don't,
don't have an objection to that.
I don't think we do.
Oop, the wrong button.
Mr. Jackson, are you on the phone?
I am, thank you. Good evening, Mr. Chairman, members of the board. J. Russell Jackson. I represent a number of abutters who are the appellees in this matter. Specifically for the record, the individuals I represent are Stephen G. Fagan, Christine S. Fagan, Susan Cohen Sawika, F. Stephen Genta, Louise Strauss, Craig Schmidt, Ann Schmidt, Jean McCabe, Maureen McCabe, Linda Haverty, Stephen E. Burrell, Robert R. Novick, and Allison F. Novick. And collectively, in the memorandum I submitted, they're referred to as the appellees. Mr. Chairman, members of the board, I will be direct and relatively brief. You've had my memorandum as well as Mr. Regan's and Mr. Martlin's for a number of months. So I'm going to presume you've had the opportunity to review and digest the arguments set forth in all those memoranda. I'd like to just, again, focus on and sort of simplify my argument. There's three elements, there's three criteria that you have to consider as you sit here as the appeals board for the planning board. One, you shouldn't be substituting your judgment for that of the planning board. It's important that it's understood you need to give consideration to how the planning board rendered their decision, how they weighed the evidence, but it's not your job to step in their shoes to determine the credibility of witnesses, make determinations on the evidence in the sense that in the same way the planning board as the actual sort of trier of fact. So what you need to look at is, one, in rendering its decision, did the planning board commit prejudicial or prejudicial procedural error? Two, was the planning board decision the result of clear error? And then three, the factor that my brother, Mr. Martlin, rests most of his argument on, was the planning board decision supported by the weight of the evidence? So let's first look at whether or not the planning board decision was the result of prejudicial error. I think in looking at whether or not there was prejudicial error, there should be sort of consideration to what that really means. In other words, was the planning board decision incorrect or inconsistent with any controlling provisions of the general laws or the ordinance, or were there procedures that weren't followed which made the process prejudicial for the applicant? In this case, I would argue that there was nothing that the planning board did which constituted prejudicial procedural error. My brother relies on the fact in his appeal and memo that the consideration that the planning board gave to environmental factors was a matter that should be left for the final plan. Well, that's just not accurate. Mr. Martlin pointed out that I cited in my memorandum the case of Polly's versus Ferrazano, which I did. And the reason why I cited that plan case was specifically for the principle that it is completely appropriate for the planning board to apply all of the cited statutory factors in giving consideration to subdivision of land at all stages, master plan stage, preliminary, and final. So there's nothing in the law that tells us that consideration of environmental factors is inappropriate for the preliminary stage and should be left strictly to final. In fact, again, in Polly's, Judge Gibney specifically states, the General Assembly has prescribed a number of factors that a planning board must consider in reviewing a preliminary plan. So again, that Polly's case was the result of a preliminary plan. So I cited that in my memorandum again, just to point out that there really is very little merit to the argument that somehow there was any type of prejudicial error which took place here in regards to the planning board giving consideration to this application and rendering its decision. Now, the second element that you as the Board of Appeals must give consideration to is whether or not the planning board clearly erred in making its decision. So, you know, this, in some respects, the argument that Mr. Martland is making intertwines this with the concept of weight of the evidence. Again, we would take the position that there is nothing in the record which indicates that the planning board committed clear error. The planning board had, as part of the record in this case, not only the testimony that was presented during the hearing, but they had the complete planning file, which included reports that were submitted prior to the hearing, which also included memorandum, communications from Crossman engineers, and by my brother, Mr. Martland's own arguments this evening, the master plan approval. So the argument that somehow members of the planning board committed error by giving consideration to, for instance, a memorandum of September 5th, 2019 from Crossman, which was later modified, or somehow there was some type of information outside of the hearing process that caused planning board members to sort of make up their minds prior to the hearing is simply inaccurate. All the items that were given consideration as reflected in the record were part of the planning file, part of the record that gets brought to you on appeal, and should either party be dissatisfied with your decision this evening, part of the record that ultimately finds its way to the Superior Court. So again, I think if you look at the record, you look at the deliberations of the planning board, it appears clear that the planning board relied on information that was available to them and it was appropriate for them to consider. Where my brother sort of intertwines the position that reliance on lay testimony not only is inappropriate in terms of meeting or for the planning board to give consideration to the weight of the evidence, but somehow was also error. Again, I would point out to the Supreme Court case, Rhode Island Supreme Court, which I will go through in a little more detail later, Restivo versus Lynch, which again specifically says that lay testimony describing physical facts and conditions does constitute evidence from which the planning board could fairly draw inferences. So just by virtue of the fact that the planning board gave consideration to lay testimony, that in and of itself is not clear error. So for those reasons, on the element of clear error, again, we would argue that the record indicates that the planning board performed its function correctly, did not commit clear error in rendering its decision on this preliminary plan application. Then lastly, again, the argument of weight of the evidence. You know, the concept, I would argue, of weight of the evidence has less to do with the accumulation of evidence. In other words, you know, Mr. Martland argues that the record is jam-packed with the testimony of his witnesses, and we don't agree with that. But, you know, the planning board, as the trier of fact, is allowed to make determinations regarding the credibility of witnesses, the veracity of witnesses. They're allowed, they weigh the evidence. So just because the transcript is packed with evidence of the applicant doesn't mean that it absolutely carries the same weight as other evidence, even though the other evidence may be limited in volume, if you will. In this case, I think it's fair game for the planning board to make assessments as to whether or not the quote unquote expert witnesses have provided testimony, both through their testimony during the hearing and their reports submitted prior to the hearing, that would meet the applicant's burden of proof. So for instance, when it comes to Mr. Aldinger, if we're going to, again, look at the actual information that he bases his opinions on, as the planning board, I'm sure, did during their deliberations, I think, as I pointed out in my memorandum, keep in mind that Mr. Aldinger himself describes his work and his report as an interpretive report. So his report is based on the interpretation of information and data he has gathered. It is not, as we saw nowhere in the record is it indicated, it's based on any actual studies conducted on the site, any testing on the site. It's an opinion rendered from general observations and information that he gathered. So for instance, these are quotes that I put in my memorandum, which are directly from the reports provided by Mr. Aldinger. The hydraulic properties of till on Middletown have not been determined. We do not have specific data which indicates the thickness of till over the bedrock. We were not able to obtain any well records with actual measured yield or actual sustained pumping rate. There are several wells in the site vicinity. We do not have information from well logs or yield data for those wells either. The recharge area for bedrock wells cannot practically be determined precisely. Since one cannot determine the location or source of all well water pumped from a bedrock well, one cannot determine absolutely if a new well will withdraw part of its water from the same source as an existing well. So again, the position of the abutters, and I think the planning board members understood this when they weighed the evidence, is that although this report and testimony was produced by Mr. Aldinger, it's based on a number of assumptions, not based on actual data gathered from the field, and it's certainly not based on anything that was studied in relation to this site. So sure, he can render an opinion and the board can recognize him as an expert, but just because he's an expert doesn't mean the board has to take everything that's testified to as absolute. They are within their rights to examine the basis upon which the opinion was developed. And if board members make the determination in weighing that the methodology or the information that Dr. Aldinger used to develop his report is insufficient or suspect in any way, then that goes towards what weight they give his opinion. Another thing I'd point out is, again, it is appropriate, and it's appropriate for the board to give consideration to lay testimony. So you see in the record that between letters that were submitted prior to the hearing and testimony that took place during the hearing, that the abutters on Prospect have existing problems with their wells. There's no question about that. You know, Jane Beezer talks about her neighbors, the Shays, had to dig deeper. They went from 125 to 200 feet. The McCarthys across the street from them, their well went dry this year. My neighbor 2 doors down, their well went dry this summer. Kevin McCarthy, again, confirming that, saying there's a lot of problems with wells up and down Prospect. I bring this up because it's important that we understand that you do not need to be an expert to provide testimony of something that you are a percipient witness of. In other words, these abutters have firsthand knowledge that their wells have gone dry. They've had problems with their wells, and they are in the vicinity of this new subdivision that's proposing 8 new wells. So again, it's appropriate for the planning board to give a certain amount of weight to facts that exist in that these wells have gone dry. These abutters have had problems with their wells. Compare that with the expert testimony that was provided, which talks about the fact that there were no surveys of abutters done to find out more information of, sort of the nature and conditions of their existing problems with their wells. And there were no studies done on site for the proposed 8 new wells. So again, it's not inappropriate to weigh the expert opinion based on certain assumptions and calculations and not field study versus firsthand knowledge of what conditions actually exist on Prospect Avenue. So lastly, I just wanted to point out that in going through that, that is an appropriate function of the planning board. I'm going to read an excerpt that I referred to and quoted and relied upon in my memorandum. And this is a Rhode Island Supreme Court case for Stevo versus Lynch. And again, it's similar in the sense that you had a developer looking to develop a subdivision. You had abutters who were concerned about drainage issues. And the quote that I think is important from that case states, "Our brother erroneously suggests that only expert testimony could competently establish the probability of the exacerbation or alleviation of the drainage conditions in the area of the proposed development. But there is no talismanic significance to expert testimony. It may be accepted or rejected by the trier of fact, particularly when there is persuasive lay testimony on the actual observed effects of prior residential construction. The subject matter here was not so arcane that inferences from factual lay testimony could not be drawn by members of the council based in part on their own expertise. In Salve Regina College versus Zoning Board of Review Newport, we held that lay testimony regarding traffic data was not competent and had no probative force. Here, lay testimony is competent in respect to the presence of water in one's basement, and such lay testimony describing physical facts and conditions does constitute evidence from which the planning board could fairly draw inferences." So I would argue, in the context of weight of the evidence, this is a very compelling and persuasive analogy to the case that you have before you this evening. You don't need to be an expert to know that your well has gone dry. And I don't think it's inappropriate for the planning board to give due consideration to the testimony of a great number of abutters who informed the board of problems that they had with their wells. So for those reasons, all the reasons set forth in my memorandum, it's the position of the appellees that I represent that the planning board did not commit prejudicial procedural error. There was no clear error in the planning board decision. And when you look at the entire record and you assign the appropriate weight to the evidence, not just cumulative, but the appropriate weight, the planning board was well within its discretion to make a determination and take the vote that they did and deny the preliminary plan application. So for those reasons, we would respectfully request that you deny this appeal. Thank you.
Thank you, Mr. Jackson. Does anyone on the board have any questions for Mr. Jackson?
I do. I have actually three questions. What other environmental issues are we considering other than the well? What other issues are we considering other than the wells?
I'm sorry, is this, Mr. Chairman, is this question for me?
Yes, sir.
Yeah, it's Eric Curtin-Russ. What other environmental issues are you concerned with other than the wells? Or are the wells a central issue? It's the only, are the wells a central issue?
Again, to adhere strictly to the record that's before you, the hearing on the preliminary plan focused almost entirely on the environmental impacts of the wells. So in other words, in this case, environmental impacts meaning what impacts will new wells have on existing wells in the vicinity. So to answer your question, there was no evidence presented to my recollection. Mr. Regan or Mr. Martin can correct me if I'm wrong, but really that hearing on preliminary plan focused almost entirely on the issue of wells.
Okay. So did the expert witness or did the neighbors, do they have any reason why they may be experiencing issues with their wells? I'm sure when wells ran dry, as you said, they had a well expert come out and gave them an idea of why that well may have run dry or what their issues may be. Can you shed any light on that?
Again, I don't want to speculate, or I don't want to pass along information that's not part of the record. So I don't have the portions of the transcript in front of me at the moment, but my recollection was that the abutters all presented relatively brief statements, and they described conditions, although they didn't get into details regarding what the possible core cause or source of those conditions were.
Okay. And then I guess the last question is, so if the testimony of the expert witness was not conclusive, are you suggesting that the only data that we could determine whether it was conclusive or not, or whether the new 8 wells would be viable, would be to drill those 8 wells, run them as they would be for a household, study them, and also study all the surrounding wells to see if there would be any effect? Is that the only way to determine whether or not these 8 wells would affect the neighboring community and their wells?
I think our argument would be, one, it's the applicant that has the burden to establish that there won't be a negative environmental impact. And we have pointed out in the memorandum and in my argument this evening that we think it's fair game for the planning board to give consideration to an opinion that doesn't rely on any testing, test wells, or on the site itself. So I'm not arguing that they have to drill all 8 wells to see what's there, but my argument would be the expert's testimony would be more compelling, carry greater weight if it were based on actual testing or some type of site data from the site being proposed, and if some type of investigation were done as to why abutters in the vicinity are having well problems. And that wasn't done. And so I think, therefore, it's fair for the planning board to consider that when they're trying to determine how much weight to assign to the expert's opinion.
Okay, thank you.
Mr. Jackson, I have one question for you. On page 6 of your memo, about a third of the way down, you state the appellant was required to submit evidence regarding the use of public water systems during the preliminary stage, and you cite Rhode Island General Law 452341. Is that an actual law or is that a practice? I'm confused with that statement.
We would argue that that's a provision that speaks to preliminary plan approval, and it makes reference to public water. And Mr. Martland referenced it during his argument.
But your comment is required to submit. That's pretty direct. That's a direct. You're saying that the appellant was required to submit evidence regarding the use of public water systems during the preliminary plan stage. So required to me means they have to go through almost like an analysis. You know, this is what it would cost to bring it in. Am I correct in that, or is that just your interpretation?
I think my argument would be there needs to be some evidence in the record as to what exists and what factors are contributing to the applicant's decision not to access public water. That would
is it stated in that law that they must, that they are required? That's I just want to be clear on that.
Yeah, I'd have to It doesn't, the language doesn't specifically state they are required to do an analysis of the cost of accessing or not accessing public water. My point was there are requirements for preliminary plan approval, and among them is information regarding public water supply. So again, some type of evidence, in my opinion, was required to be put into the record regarding public water.
Okay, thank you. I was just concerned about that required point. Thank you. Does anyone else on the board have any questions for Mr. Jackson?
Yeah, that was James Miller for the record. This is Tom Heaney. First, I want to confirm one thing, Mr. Jackson. You made a statement that said that their expert testimony was really based on geological studies. No real tests were done on the site at all. I just want to be clear that that's what your statement is surmising.
Correct. I don't think there's any evidence in the record that the applicant's expert conducted any test wells or any type of significant testing or analysis of the site itself.
Okay, thank you. Then I'd like to direct a similar question to Mr. Martland and ask if that's also your position, that your expert testimony was based on the individual's background as a geologist, but really didn't do specific tests on this site to substantiate the claims that they were making. Is that true?
When you speak of tests, we didn't do flow tests, and we didn't install wells and draw water from wells. So the expert's report is based on the available information relative to the types of soils, the type of bedrock, the amount of rainfall, in determining how much recharge you get into a site. So unless you installed 8 wells and ran 8 wells like a normal house, and everything else is going to be, what experts do, which is taking into account the surrounding area, the nature, the geology, and coming up with that opinion.
Okay, so I'm not specifically asking about drilling the well, but I am specifically asking about soil samples, any kind of core samples that they may have done at the particular site to confirm that their suppositions were correct. So
Well,
go ahead.
Yeah. So were there soil samples taken? Soil samples were taken. They were not taken by Mr. Aldinger. They were taken and conducted by the engineer of record, Northeast Engineers. So they had to do a variety of samples to determine groundwater levels, and that information was shared with Mr. Aldinger.
Okay, thank you.
If there's no other questions for Mr. Jackson, Attorney Jackson, I'd like to ask Attorney Regan to present.
Thank you, Mr. Chairman, members of the board. Peter Regan here tonight representing the Middletown Planning Board. This matter has been extensively briefed. I know you've all read the briefs, you've all read the transcripts and the records, so I like Mr. Jackson, will try to be brief here. I wanted to just start off once again trying to emphasize what your job is here and what your job is not. As noted in Ms. Desautel's memo, review of a planning board decision is limited. You're not here to substitute your judgment for that of the planning board, and it's not your job to rehear the application or determine how you might have decided it if you were on that board. And even after reviewing the record, you believe you might have decided it differently. That's not the standard. You can only reverse the planning board's decision if you find either prejudicial procedural error, clear error, or lack of support by the weight of the evidence of the record. And it's our position that none of those factors are present here. And I think it's important as we review this to take really two things into account. First, the appellant, in our opinion, failed to prove that the plan to install these 8 wells instead of and in lieu of public water would not have a significant negative environmental impact. And second, he failed to present any evidence or rationale whatsoever for why this public water couldn't be brought to the site. And having read the planning board's decision and having reviewed the transcripts, you are well aware that the main point, really the only point of a discussion during the public hearing at the preliminary phase, and the reason why the board denied the application was the plan to have the subdivision serviced by private wells instead of public water. So, regardless of what Mr. Martland says, there's no mystery here as to why this application was denied. And the appellant had the burden of proof to show that there would be no negative environmental impact as a result of that plan. And frankly, he failed to meet that burden. Now, the argument that my brother, Mr. Martland, makes is that the expert testimony regarding the wells is essentially unchallenged and should have been accepted by the board. But when you look closely at the record, you're going to see that that expert testimony was full of qualifications and unproven assumptions that, in our opinion, the board was free to reject. You're also going to see that the expert's conclusions were not supported, as Mr. Jackson pointed out, by any data specific to the site. It was based on assumptions, based on the general geology of the state of Rhode Island, and in some cases, general geology in other parts of New England outside of Rhode Island. You'll also see that the two experts, Mr. Aldinger and Mr. Cabral, came to wildly different conclusions as to the potential impact of the wells. Now, I'm not saying that Mr. Aldinger and Mr. Cabral aren't smart guys, they are. But when you take a deep dive into the record, you see how limited the information was that they had to work with. And as a result, how their conclusions are based more on assumptions than on hard specific data about this site. So, and I'm going to try not to cover too much of the same ground that Mr. Jackson did, but Mr. Aldinger had to make assumptions about the hydraulic properties of the till in Middletown because the report says those properties in Middletown have not been determined, and he actually references properties of till in Connecticut. He made assumptions about the thickness of the till over the bedrock, saying we don't have specific data which indicates the thickness of the till over the bedrock in that area. Once again, something that a test hole or a test well could have determined. He admitted that they lacked any information about the existing wells in the area, wells that might be affected by these new wells, and that the recharge area for the wells couldn't be precisely determined. He also admitted that they were unable to determine if the new wells would draw part of their water from the same source as the existing wells in the immediate area. So as a result, we don't know if the new wells will have a negative impact on the existing wells. And because the appellate didn't obtain any data on the existing wells, didn't drill any test holes on the site, we don't have any data that's specific to this property. So in answer to Mr. Heaney's question, what we have instead is assumption on top of assumption on top of assumption. And that is the type of expert testimony that the board is entitled to reject. In addition, you've got significant portions of Mr. Aldinger's testimony that were contradicted by Mr. Cabral. Mr. Aldinger testified that there'd be 2.3 million gallons of groundwater recharge on site with a total consumption of 1.3 million gallons for an annual net gain of 1 million gallons. of recharge. On the other hand, Mr. Cabral testified that based on his analysis, there'd be a balance between recharge and demand, and then in worst case scenarios, there'd be a deficit. In other words, you'd be actually drawing more water from the ground than is being recharged into the ground. Now, that's a difference of at least 1 million gallons of recharge a year. That's a huge difference of opinion on a very significant issue. Mr. Martland says, well, they agreed on everything else except this one. Well, this was the big issue. This is the analysis that would show whether the new wells would negatively impact the existing wells in the area. And, you know, regardless of what the appellant says, Mr. Cabral testified that relying on wells was a bit of a gamble. And you can try to explain that statement away, but a gamble is a gamble. On top of that, as Mr. Jackson noted, you did have several abutters testifying about problems with their existing wells in the immediate area, including those wells running dry. And that is precisely the type of observation lay testimony that the Rhode Island Supreme Court has said the board can consider in the Restivo versus Lynch case. Mr. Cabral also stated, as noted by Mr. Martland, that the new wells might have a negative impact on those adjacent public wells. That is, frankly, a negative environmental impact by definition. And there's no exception in the law for that impact simply because the appellant happens to own the abutting property. Now, under all of those circumstances, in light of the failure to drill any test wells or do any further investigation that might have provided some actual substantive data related to this site, the board was well within its rights to reject the expert testimony. This is not a situation where the board has to accept the testimony of any of the experts. Based on all of the circumstances, the board was entitled to reject it, and that is in line with rulings by the Rhode Island Supreme Court. And you need to remember, in that case, the appellant had the burden of proof to show that there would be no negative environmental impact. Wasn't up to the abutters to prove it, wasn't up to the board to prove it, was up to the appellant, and he failed to meet that burden. And that's particularly true where the appellant didn't provide any reason or rationale why public water service was not a viable option to the gamble that was presented by the wells. Now, the appellant at the preliminary review spent a good deal of time at that public hearing discussing the proposed wells. However, there was no evidence whatsoever presented as to why the wells were necessary and why the public water couldn't be brought to the site. And that's frankly surprising, given Mr. Cabral's statement that water was located near the site. In fact, that water was located in the immediately adjacent subdivision to the west on Terry Lynn Terrace. So considering the uncertainty surrounding the wells, the inability of the appellant's expert to prove that there would have been no negative environmental impact, we believe it was incumbent upon the appellant to explain why the certainty of a public water system wasn't a viable option. I think under the statute that was cited by Mr. Jackson, I think he was required to do that. Regardless, he's still got the burden of proof. And if he doesn't do it, he does that at his peril. And if you think about it, there were two options here. The wells that might work, might not. The other option, public water that would eliminate any concerns that come with the wells. But we don't have an explanation anywhere in the record as to why that option wasn't chosen. Appellant provided no information as to why the water couldn't be brought to the site, no evidence as to where the lines were, no evidence of the cost of extending those lines, no evidence to support any contention that doing so wasn't feasible. In fact, the only evidence in the record is that the water was in the abutting subdivision immediately to the west. So in my opinion, the failure to explain why that water couldn't be brought the short distance from Terry Lynn Terrace alone justifies the denial of the application. Lastly, Mr. Marlin argued in his memo, didn't argue it tonight, but I just want to address it briefly, that the board committed procedural error by making the findings of fact that are required by state law and the subdivision regulations at the preliminary phase of the review rather than at the final stage. And that argument simply doesn't make sense when you consider how the subdivision review process works. Under both state law and the town subdivision regulations, there are 3 phases of review for a major subdivision: master, preliminary, and final. Generally speaking, master phase is conceptual in nature, involves a review of the proposed layouts, the proposed number of lots, doesn't require the submission of any detailed engineering. On the other hand, the preliminary phase is where the bulk of the review process takes work, including review of detailed engineering, including septic systems, water systems, et cetera. And as Mr. Martland noted, in the master plan review decision, it was made clear that any analysis of the proposed wells was going to take place at the preliminary phase. And that was in there, and I mentioned it at the master plan phase because everyone knew at that point that the wells were an issue. We knew that there were concerns. The butters had raised concerns about the wells, and it was made clear to everyone involved, including the appellant, including the abutters, that those issues would not be dealt with at master plan because that's not where those take place. Those take place at the preliminary plan. And in regard to that, I just want to make it clear, any suggestion that the board somehow approved the wells because they were on the conceptual plan that was approved at master plan is completely false. As noted in the statute, as noted in the decision, there was no analysis as to the appropriateness of those wells, and everyone was aware that those were going to be dealt with at the later preliminary plan stage. But with regard to the findings that the board is required by law to make, given that the bulk of the work, the bulk of the review takes place at preliminary, it would make no sense for the board not to make the findings at that stage. And in addition, the final plan review, where Mr. Martin says these findings should be made, sometimes doesn't include the planning board at all. If the town planner determines that the final plan submission is complete and meets all the requirements of the subdivision regulations and any additional requirements set by the board of preliminary, the planner can approve the plan without referring it to the planning board at all. So if you follow Mr. Martin's argument to its logical conclusion, if you wait until final plan, you may not have any findings, because if the board's not involved, they can't make the findings of fact, and you'll be out of compliance with the law. So clearly the board acted properly procedurally here by making those findings with regard to the wells, with regard to the negative environmental impact at the stage where it considered those issues. So, based on that, I think it's clear the weight of the evidence is in favor of the board's decision. There was no clear error. There was no clear procedural error. And I think based on, once again, the multiple assumptions underlying the expert's report, the lack of any site-specific data, and the wildly different conclusions that the two experts came to, the planning board was within its rights to reject the expert's opinion and deny the application. So based on all of that, we'd respectfully ask for you to deny the appeal.
Thank you, Mr. Regan. Does anyone have any questions of Mr. Regan?
Yes, I have one. This is Eric Curtin. Peter, you mentioned that they could have tied in to the Terry Lynn terrace.
I don't know, but the only thing in the record indicates that the water was, and I think Mr. Martland actually mentioned it during his discussion, it was stated by Mr. Cabral in the record that public water was available in the subdivision immediately to the west of this site, which is the Terry Lynn Terrace subdivision.
I would gather it's also available on Aquidneck Avenue that you can pull down from Aquidneck Avenue.
I don't want to. I don't want to state things that aren't in the record. And there was no discussion about the availability at Aquidneck Avenue or Paradise Avenue or anywhere else other than the subdivision immediately to the west.
So this is Tom Heaney. So the point of fact, Mr. Reagan, that you're trying to make is that that avenue wasn't pursued. There was no real consideration for bringing water to the site other than drilling the wells that were proposed.
Yeah, there was nothing presented to the board. You had on one hand the proposal for wells that might work, might not work. On the other hand, we know that if public water is brought to the site, all the concerns that are related to wells go away. And there was no discussion, rationale, argument, evidence whatsoever as to why that option wasn't taken. And, you know, given the lack of, I would say, conclusive evidence that the wells would not have a negative environmental impact, the failure of the appellant to provide evidence with regard to the feasibility or unfeasibility of bringing public water was fatal to his application.
I think in 2018, in the master plan discussion, this is, I guess, a question for both you, Dave, and Peter. Dave, you stated that it was infeasible to do it. So I guess the question is for both of you. It sounds to me like it was discussed, and two, if it isn't feasible, why?
Well,
Yep.
and that's there's a notation saying that the applicant said he was doing wells because it wasn't feasible. There was no evidence presented as to why it wasn't feasible, and certainly at the preliminary phase, which is the phase which is the subject of this appeal, there was no discussion or evidence as to why it was unfeasible or not.
Well, it was discussed at the master plan stage. This is David Martland. Yes, there is a notation in those minutes relative to that. The question did come up, and we had indicated at the master plan stage it was looked into, and my client determined that it was not feasible because of the distance.
Well, that wasn't mentioned in there. That's not part of
It
the
may
record.
not be in the minutes, Peter, but
it's not part of the record, and so we shouldn't be considering things at this stage that are not part of the record on appeal.
Well, you put this issue into play by making the argument that we had to present it at the preliminary plan stage.
Well,
and this is the only time at no time before the submission of your memorandum or Mr. Jackson's memorandum was this ever suggested that we would need to put this evidence into the record.
Well, it's not the job of the town or the planning board to tell you what evidence needs to go on the record or not. You've got a burden of proof, and you have to make a decision as to how you meet that. And particularly when the wells were a major concern, and frankly, the only concern from the abutters and members of the board, the decision of what you put in or don't put in is up to you. But it's not up to the town to tell you how to or your client to present its case.
I'd like to respond to the board and not have a direct discussion with Mr. Regan here. My client's application was certified complete. It's a complete application. we were at the technical review and stage with the technical review committee and the town's engineer and the independent reviewing agent for 2 years before going to the planning board. There is nothing in either state law or in the regulations of the town that require any applicant to prove the availability or unavailability of the water, the public water. So there is absolutely no burden on my client to deal with that. The issue was discussed, as noted in the minutes, at the master plan stage. The plan was approved at the master plan stage with knowledge that we were moving forward with the wells. And I'm not saying that the board couldn't, have, further review of that particular issue. Obviously, that would, was still going to become an issue. And we would need to present evidence related to that, but there was no requirement to provide any evidence regarding the public water system. I would also, indicate that Mr. Regan said that I put in my brief that these issues could not be considered at the preliminary plan stage. I think he is mistaking the initial notice of appeal I filed with the memorandum I submitted. So initially I had filed the notice of appeal. I did include that issue saying that these matters could not be reviewed at the preliminary plan stage. I did not press that issue in the notice of appeal. So, that issue is not being pressed in front of the board this evening.
Mr. Chairman, if I might just reply very briefly. First of all, certification of an application simply means you've provided all the materials on the checklist. Doesn't mean that the plan's approved or that the board, frankly, at the time it's certified as complete, the board hasn't even seen it. That's just certified by the planner saying, yeah, these are all the items on the checklist. You've provided all the items on the checklist. It's complete. Now we can proceed to actually review it. So that doesn't mean anything with regard. It's no seal of approval on what's being presented because the board hasn't even reviewed it at that point yet. And I would just say lastly, we're arguing back and forth of whether they've got an obligation to provide this information as to why you couldn't bring public water. But when you present a plan that may have arguably has a negative environmental impact, the failure to explain why you're not bringing the public water, if you fail to do that, whether you're required to do so or not, you do that at your peril. And that's all I have to say.
I think we've heard enough on that issue, Mr. Regan, because
Thank you.
again, I don't want to go off what's in the record of the planning board meeting. So I think we need to stay focused on what's in the record.
Isn't every meeting part of the record though?
Yeah.
Master plan, preliminary plan, final, all part of the record.
Yeah, that's correct.
I don't understand why we can't discuss what was discussed at the master.
We can, but we've gone over
I
requirements.
seem to be bypassed.
Hey, Jim, this is Chris Souza. Can you hear me?
I can hear you. Go ahead, Chris.
Yes, Marissa, a question, a legal question. Are you there, Marissa?
Yes.
We're supposed to listen to the evidence, make a decision based on the evidence. Procedural error, clear error, or lack of support by weight of evidence. Now, in order for us to draw a conclusion about lack of support for weight of the evidence, that requires a little bit of common sense and past experience, personal experience, weight of evidence. If we're weighing things, are we using our own, for instance, I have 3 wells and they all went dry this summer. I know that wells dry up during hot weather. Am I allowed to use that? It does kind of relate to the neighbors. How are we supposed to weigh one person's evidence over an expert witness's evidence unless we use our own common sense?
Okay, so there were 3 questions, I think, in that. Let me see if I can answer them in order. The standard that you should be using, and you got it right, that you're restricted to the evidence in the record, but the standard that you should be using is whether there's competent evidence in that record to support what the planning board did. Secondly, you had a question about whether you could rely on your own personal knowledge. No, you cannot supplant your
But
thought.
the planning board is using layman's.
Chris, can I finish?
Sure.
You cannot substitute your opinion for what you think the planning board should have done. You can only look at what they actually did do and then take a look at the record to see if the evidence in the record supports that decision. Go ahead. What were you going to say?
It just puts us in a catch-22. I mean, we have expert witnesses come in and we're supposed to give them credibility.
So whether you certify someone as an expert is up to the planning members or the board members at the time. But once an expert is admitted, you still have, or the planning board still had an opportunity to weigh their credibility. And that's a very important role because through case law, the Rhode Island Supreme Court has told us that it's really important that the one-on-one which occurs between the finder of facts, which would be the planning board in this case, and the witnesses and the expert witnesses, that can only be done in person. I mean, it's virtual right now, but the theory is that looking at someone testifying, you as the finder of fact might give more credence to expert A versus expert B. And there are a litany of reasons that you might make that decision. Number one being experience, testimony about their resume, education, what they actually did in the specific case to educate themselves about the site itself, and the process that they used. So you've got a lot of different, the planning board had a lot of different factors that it used or should have or could have used when looking at the different experts. So it's not just that once an expert is certified, they all are on the same level and you have to accept everything that they say.
Okay, thank you.
Marissa, is this like a normal hearing? Do we shut down the comment from the attorneys and then go into discussion?
Yes, you can. Yes, and that's what I would recommend.
Does anyone on the board have any questions for any of the attorneys?
I have a question for Marissa. Marissa, can you in layman's?
Well, if that's for Marissa and it has nothing to do with it, I want to, okay. That's what I'm getting at. I want to have those discussions, but I want to have it once we close the record. Okay. So am I correct in saying that we can close the public record now?
Hey, Jim, just one more question.
Okay, Tom Heaney has a question.
So just as far as the record is concerned, we've talked about a number of times the term significant environmental impact. And the only thing that I see in the record, the only thing I've heard discussed is that the significant environmental impact that we're talking about in this case has everything to do with whether or not there could or could not be enough water available if these wells were drawn or drilled. So I just want to make sure I got that right and there's not something else that I missed in the record, other environmental impacts by putting these residents in this general vicinity. Am I correct?
Who's that directed to?
Any party, lawyers on either side, I'm sure can have an opinion on that.
Mr. Chairman, Peter Regan here. I would agree with that. And I just would to clarify whether there's enough water for these wells or whether digging these wells would have a negative impact on the other existing wells in the surrounding area. But if you look at the record, I don't think were any other concerns about negative environmental impacts that were noted by the board.
Yeah. This time.
I would concur with Mr. Regan. You know, we presented the testimony of Lynn Small, who was the project engineer, to testify regarding the storm drainage system. We submitted the permits obtained from the Rhode Island Department of Environmental Management related to that. And I don't think there were any issues that anyone had related to those matters. So this would be the only potential environmental issue that is of issue.
Chairman, this is Dave Huntoon at home.
Go ahead, Dave.
Just a question, I believe, for probably Mr. Regan, not specific to his role on this appeal, but more specific to his role as a solicitor and providing maybe a little bit of background information on the process that was followed in bringing this before the planning board. And Mr. Regan, if you could, as I understand it, it was brought before the board, the planning board, as a combined preliminary and final plan approval. Is that correct?
Peter, you're muted.
Sorry, it's late. I'm usually better at that. So you are correct, Mr. Huntoon, that it was heard as a combined preliminary and final. And I think at the end of the hearing, the board changed it to just a review and a vote on preliminary. And I believe that's in the record, and maybe Mr. Martland can correct me if I'm wrong on that, but I believe that's what happened procedurally.
That's correct. I concur with that.
Okay, thank you. And I just wanted to make sure that I remember reading something along the lines as well. So at the end of the day, it's the information that we're looking at as the appeal board for the planning process is that at the end of the day, when the planning board met and voted, they did so with the understanding that they were doing so in a preliminary planning approval stage rather than a combined preliminary and final. So that is correct.
That is correct.
That's the only thing I had, Mr. Chairman.
Thank you, Mr. Huntoon. Is there anyone else on the board that would like to ask a question of the attorney?
Mr. Chairman, Olin Gambrell. Mike, I've got a question. Is the average well that's drilled over there is between 130 and 150 feet. Why on this new one, they propose to drill the new wells a minimum of 500 feet? Why is there such a large difference? Is Mr. Martin could answer that?
Yeah, I can, Mr. Gambrell, I can answer that. That was a condition that the town's independent engineer requested. I believe we were proposing wells in the range of maybe 300 feet. The town's engineer wanted those wells to go to 500 feet so that there would be an increase in the amount of storage that was available in the well itself, which I believe, and I'm just trying to go off my memory here, that it was calculated there would be some 750 gallons of water that could be stored in a 500-foot deep well, and so that would provide potentially 3 or 4 days of usage. And so that when you would draw down some of that water, for day one, you would have the infiltration could begin, it would be, it was so that you wouldn't run the risk or the gamble of the well running dry during certain times of the year.
So it wasn't a decision that was made because of a lack of water in that area?
No, it was it was, I think Mr. Cabral testified to this, that he proposed that condition, and it was based on his experience in other communities in which, you know, a 100 or 200 foot bedrock well might run dry, and then you would have to go deeper. And so he wanted to see these initially put in at 500 feet.
Thank you.
And seeing that's the last question, I'd like to close the public portion of the hearing, and I assume, Marissa, that we take a motion and then we open it up to discussion. Is that how we do this?
Yes, that's correct.
And I have a motion to, in the positive, I guess, I need a motion to uphold the planning board decision.
So I'm making a motion to uphold the planning board.
Actually,
Yeah, I thought you were making a motion to close the public testimony portion.
I do want to close it, but usually we close it with the motion of a affirmation. So I'm not sure how we do that.
Mr. Chairman, I believe the motion would be to, if it's going to be in the affirmative, the motion would be to uphold the appeal,
Right.
which would be
Am I correct?
to reverse the planning board decision, but to
Is that
uphold the
how we-
appeal.
Is that how we close this and then get to discussion?
I motion to close, Mr. Chairman.
No, exactly. That's correct.
Mr. Chairman, I would motion to close the hearing and open the discussion.
Well, we need to do it on a motion, so.
Yeah, I'll motion to close the hearing.
No, I'm talking, I think, Mr. Regan?
No, I was saying if, once you close the hearing and then you make a motion for discussion on the appeal, and assuming everyone agrees, the motion should be to if you're doing the motion, the affirmative, the motion should be to uphold the appeal.
Right, and then we open up discussion and we can vote any way we please, correct?
Correct.
Great.
Okay, that's what I thought. So,
So I'll make a motion to uphold the appeal.
do I have a second? I need a second.
I'll second. Oh,
Yeah, I don't think you're
Mr.
voting.
Souza, no.
Chris,
Excuse me.
Chris Souza, you can second. Up, Tom Silvera, second. We have a first and second. I'm going to close the public hearing and we're going to open it up to discussion. My first discussion, first off, will be with Marissa. Marissa, I just have a question for you regarding what our options are. We can uphold, we can turn it down. Is there any possibility that we can uphold with conditions?
You can reverse in whole or in part, and then it would get remanded back to the planning board for further review in light of that determination.
Okay, that's what the question is. So if we so my thought process here is I wanted to go down each area and clear them off the table. Prejudicial, procedural error, clear error, and then lack of supporting the weight of the evidence in the record. And then, you know, entertain discussions on what we should do. Does that seem like a logical way to do this?
I don't know if that question was aimed at me, but yes.
It was. You're
Yes.
the only one I want to talk to now. I don't want to talk to those other three guys.
Yes, that makes sense.
Okay, thank you. Okay, so I just thought that would make our discussion more pointed, is if we went down the three criteria and just talked about them. And so the first criteria that they brought up was prejudicial procedural error. Does anyone on the board feel that there was any of that involved in this decision?
I don't know. I don't think that there was any prejudicial procedural error.
Does anyone have issue with that?
No.
Okay, so the next area.
I don't have,
What's that?
Chris Souza, I don't have any issue with that.
Thank you, Chris. The next one is there a clear error that was made in the petition?
Again, Eric Curtin, I don't believe that there was a clear error made by the planning board.
Tom Heaney, I also agree. There was no clear error.
I don't either. Is there anyone that sees it? So it seems like we're all in agreement there. The last and probably the trickiest one for all of us is going to be the lack of support by the weight of the evidence in the record. That could be a point of discussion, I'm sure. So,
So I've been wanting, Marissa, can you, in layman's, describe what lack of support by the weight of the evidence is? I find it to be a tricky thing.
Yes. So the way that the Superior Court has decided to define this particular phrase is whether competent evidence exists in the record. So what does that mean? Well, you have to take a look at testimony, exhibits, the transcript, and make a determination about whether the planning board had information before it at the time that it rendered its decision, which supports the way in which they ruled. The most obvious example of that would be if, in this case, there was no evidence provided by the applicant, either by a fact witness or an expert witness on a particular topic. I'm just going to choose stormwater erosion for an example. You would take a look at the record and say, there was no evidence presented and the planning board could not have made a decision on stormwater erosion because they didn't have any information before them that they could rely on when rendering that decision. So that's a really obvious answer. And I recognize, Eric, what you're saying, that it is a difficult decision to make. Each one of these cases is very fact specific. And so I would just urge you to, I'm sure you've read all of the pleadings and looked at the evidence in the transcripts, but go back to what you were able to glean from that review and make a decision about whether you think there was evidence, competent evidence that the planning board had before it to decide the way that it did.
Marissa, I'm just going to ask the question because I'm not very delicate. I've been described as caustic and abrasive, so excuse me if I'm direct. Is there any way for us to remand this back to the planning board for consideration if the applicant brings public water to the site?
At this point, all you can do is make a decision based on those 3 exceptions that I included in the memo, upholding and affirming the decision if procedural error, clear error, or lack of support by the weight of the evidence in the record do not exist, or reversing the decision in whole or in part and sending it back for further review in light of the determination. So it sounds like what you're asking is if you can reverse the decision in whole or in part and send it back with further instructions for them to reconsider. Is that what you're asking?
Yes, to reconsider only if it's, I mean, if we don't have that option and all we can do is make a decision based on the well, that's one thing, but can we send it back for further consideration if public water was used as the source?
No, all you can do is look at what the planning board had before it at the time it rendered its decision.
Well, can we send it back without that?
Yeah.
Without the final statement?
I'm sorry, Eric. I think I didn't catch the last part of your question. If that was.
How can we, without putting in any conditions, how can we remand it back to the planning board for further consideration?
You would only be remanding it back for further review in light of your determination. So if you were reversing a section of it and saying, we don't agree, you'd send it back to the planning board, but they would have to, again, move forward on the information that they currently had or had before them at the time they rendered the decision. You can't send it back and order a new hearing. Something that would be up to the applicant as to whether they wanted to request a change in their application, but you can't pick and choose what you're going to send back with instructions.
Would they have that option when it went back? No.
I don't know.
Mr. Chairman, are you thinking about the data, the expert testimony on the data supplied about the well water?
Yeah, I'm thinking
versus bringing in, city water, town water.
Right. I only see in the record passing discussions about that. I don't see anywhere where it was specific. I see in Mr. Jackson that it was required, but I see nowhere that strong language was used in the hearings. And you can use the argument that it's up to the appellate to do it, but I don't see equal weight given to that. So I don't know, but if we don't have the ability to do that, we don't have the ability to do it.
Well, there was testimony in there about the expert testimony on the data. So couldn't the Board of Appeals refer it back to the planning board on the basis of the findings in the expert testimony on the data on the water and let?
I think they made their decision based on that. Any discussion from the board?
I have some thoughts. This is Tommy. If I misstate something here in terms of what we have been told, in terms of what we're here to adjudicate, please, Marissa, jump in. But from where I sit and from what I've heard, if I look at the standards that we've been given, procedural error, clear error, weight of evidence, I would say, in my opinion, that there was no procedural error. And therefore, if there was no procedural error, there probably could not be any clear error. So when you get down to it, it really is based on the weight of the evidence that was presented. And as far as the weight of the evidence that was presented, even though there were expert witnesses presented on the behalf of the appellant, it did not seem to me that the expert witness went to the extent that they should have done to make any substantial proof in terms of evidence of doing things on the actual site that would make either the planning board or now us, the zoning board, believe that what they were surmising from their expertise, and I don't disagree that the individual is a geological expert, far more informed than I, but however, on the preponderance of the evidence that's presented, I do not believe that the weight of the evidence is on the side of the experts, and I am more in favor and inclined to believe the lay witnesses who have lived there and have expressed concern over the addition of these additional wells in this vicinity.
Isn't it impossible for them to get real hard data? I mean, without actually drilling?
This is the issue I have with all of this.
Without actually drilling 8 wells, running them as a household would run them, compare what's going on in the neighborhood wells with that over years. I don't know how it's possible for them to come up with the data that the neighbors are asking for, or that Mr. Jackson is asking for.
Chris, go ahead. Chris Souza.
I guess it may have dropped. But again, to finish my thought, as far as I'm concerned, it's all right, Eric, but I don't disagree with you, but what I'm trying to say is, based on what we have read, what we've been presented, I don't find the expert witness to be any more compelling than the neighbors who are concerned about whether they're going to lose their water or not. It just, to me, there is no weight, as we're talking about weight of evidence. There's no weight in their favor just because the guy has a degree, like the folks that live there. I don't find it compelling, and therefore, I would not vote to uphold the appeal. I would actually vote against it.
Discussion?
I think I was muted, Jim. Chris Souza here. I agree with Eric Curtin. I don't know what kind of tests you can do on a lot to find out if it's going to impact the adjacent wells across the street, especially not knowing the age of those wells, how long they've been in service, how deep they are. I think the best standard we have right now, as far as I know, I mean, maybe someone could tell me otherwise, is what these expert witnesses provided. They hired a geologist, they hired the town engineer, they both signed off on it. Maybe in the future there's a better protocol, but I would say this probably falls in line with a standard that's been accepted before, and all of a sudden it's the new red herring.
And Mr. Chairman, this is Dave Huntoon, if I may.
Yes, go ahead, Dave.
I think that as members of the board that are looking at the evidence that was presented, the fact that there were two experts who, as Mr. Regan pointed out, Mr. Russell as well, who differed arguably dramatically on what the impacts of those 8 wells would be, as well as the idea that the plan for those wells that would be installed in the 8 wells as part of the subdivision were going to be arguably over 2 times as deep as the wells in the area, to arguably ensure that those wells would have, the last water available when the local folks would not, I think bears considerable weight when we try to determine if the planning board adequately weighed the evidence that was presented before them when they made the decision they did. And Mr. Chairman, if you could also maybe verify who is voting from the zoning board on this now, just so there's no debate later that someone should or should not have been voting. I think that would at least be helpful to myself as an alternate member.
Yeah, tonight's voting members are going to be Eric Curtin, Tom Silvera, Jim Miller, Chris Souza, and Tom Heaney. They're the regular members, and we're all in attendance.
Hey, David, do you have a background with wells? I'm just curious.
Gentlemen, I just want to point out that we've got to look at only the evidence.
Correct.
So I don't want to go on I don't want to go off on a side.
Correct. Because digging a well deeper provides more water because there's more casing.
I understand that as well, Chris.
Okay.
But I think what we have to do is we have to determine what the planning board did on the date that they did it. And we can't talk about things that weren't talked about at that meeting. So if anyone else wants to put their comments on the record, Chris, why don't we start with you?
Well, like you, I'm direct. I'm going to go with the expert witnesses in this case, and I'm going to vote in favor of the appeal. And I'm going to just keep it short and simple and say that I'm going to agree with the expert witness testimony. And that's all I have to say.
Thank you. Eric?
I'm going to agree with Mr. Souza. I think at the end of the day, the expert witness was competent. And, I'm going to vote in favor of the appeal.
Mr. Silvera?
All right. I always get yelled at, but they can't. Anyway, it's a very difficult decision. I've been on the board for 30-some years, and I've you know, we've had a lot of things. This is very difficult doing this in Zoom. It's something that's never been, that we've never had a case like this in Zoom, so it's a very difficult decision. But anyway, I'm also going to go along with my colleagues because I believe that the experts should know what's going on. And it's impossible to put test wells and stuff like that.
You're cutting in and out. I'm sorry. I just want to make sure I get everything correct, but you're cutting in and out.
What's that now?
She could hear me.
Yeah, I'm speaking into it. Okay, what did she ask me? I'm sorry.
What was your vote?
Oh, speak louder? Oh, okay. All right. Anything else? What didn't you hear?
I didn't, you cut in and out throughout your whole statement. So it was bits and pieces of something. I'm also going to go along with my colleagues because I believe that the experts should know it's.
I said, I believe the expert testimony was valid. So I'm going to vote along with them.
And I'm the last one that needs to chime in. My name is Jim Miller. Based on the evidence that was presented at the planning board meeting, I have to side with Mr. Heaney. There was no procedural error. There was no clear error. And I think when it came down to the support of the evidence, I think that the planning board made the right decision, taking into account the concerns of the neighbors that live there and the potential negative effect on the wells. However, I wish we could have remanded it back for a public water because I think that would have served Middletown better. But having said that, it's time to take the vote. I know what the vote is already. All those in favor? Aye.
Aye. Aye.
Mr. Souza? Chris? Come off mute. You need to vote.
Aye.
Chair, could you just read into the record what the actual vote is, please?
So for the record, there was 4 yays and 1 nay. Chris Souza, yes. Eric Curtin, yes. Tom Severa, yes. James Miller.
No, they're voting you're voting to turn the appeal down, to approve the appeal.
No,
I'm voting to approve the appeal.
You need to say who's speaking because I cannot see you. I'm sorry.
This is Chris Souza. I'm voting in Mr. Goldstein's favor.
So if you are voting to in favor of the appeal, then I suggest that you phrase your motion that you are voting to affirm, excuse me, to reverse the decision of the planning board.
This is Chris Souza. I am voting to reverse the decision of the planning board.
Thanks, Chris.
This is Eric Curtin. I'm also voting to reverse the decision of the plan.
And I said the same. I said the same thing. Reverse.
And how about you, Tom?
I'm voting to support the decision of the planning board.
And I'm voting to
Wait, excuse me. Again, you need to state your name because I don't know who you are.
This is Tom Heaney. I'm voting to support the decision of the planning board.
And this is Jim Miller. I'm voting to support the decision of the planning board. So the planning board is overturned on a 3-2 vote.
Is it appeal 3-2 or is it 4-1?
I don't know. Marissa, what's the vote for an appeal?
Read it too.
A vote to reverse the planning board's decision requires at least 3 of 5 votes.
Okay, so the decision of the planning board is reversed. Motion to adjourn?
Just one more point here. The statute requires that a written decision be issued within 10 days of the close of the hearing. I recognize in my memo that I cited that incorrectly. My apologies, but it should be issued within 10 days.
Who writes that, Marissa?
I can coordinate that if you'd like.
That would be awesome.
Okay.
Can I have a motion to adjourn? Motion made, second.
I don't know who made the motion.
Tom Silvera made it. Eric Curtin seconded.
All right. I don't know if anyone needs a copy of the transcript or not. If you do, can you tell me?
Marissa will need a copy to write the opinion.
Not not necessarily. So I
Oh.
think we can, probably won't know whether we need copies of the transcript until after the decision's been entered and we determine if there's going to be any further appeal. So,
Yeah, and I won't be able to get that to you. It would be 10 business days.
yeah, I don't think we need the transcript in order to prepare the
Okay.
decision.
No
so,
problem. Thank you.
Thank you.
Everyone have a good evening. Thanks. Bye.